Okay, so let's come back and we'll start looking at some of these cases. And one of the things that they talk about in West versus Low Pipe, that's on page 251, right. West versus Low Pipe. We're trying to talk here about illegal cause or unlawful cause. And this case has somewhat, I would say, somewhat convoluted facts. I'd like you to take a look at, let's see, articles, Louisiana Civil Code articles 2983 and 2984. 2983 and 2984. Okay? 2983, and I want you to guess when the last time these things were revised was. The law grants no action for the payment of what has been won at gaming or by a bet, except for games tending to promote skill in the use of arms, such as the exercise of the gun and foot, horse and chariot racing. And as to such games, I guess these would be the legal gambling games, the judge may reject the demand when the sum appears to him to be excessive. Okay. Now I'm going to go into the detail on this in sale and lease. It's because of history, but this is essentially what this case is referring to, is 2983. Okay. So what happens here? Yes, sir.
Okay. So the
plaintiff claims that the defendant owes him money, right?
Yes. So they were together riding. They go to a plaza, and although if gambling is illegal, they hold like poker tournaments
Upstairs.
Yeah, upstairs for entertainment purposes, I guess, for guests. And so, in the course of gambling, the guy borrows, the defendant borrows money from plaintiff.
Essentially from the house, yeah, because the plaintiff is like the manager of this place or the owner or something.
Yeah, he's worked there a few times. He has sort of an interest in what goes on, sort of. And so, the plaintiff pays the debts of the guy, the gambler, bad gambler.
He's borrowing money from everybody. So he not only loans the plaintiff, not only loans the defendant money, he also pays loans that the defendant when he's borrowing money from other people there.
Everybody. Okay. And so basically he's suing to recover those debts.
Okay, so what happened? What do you call it? Do you remember what you call it when you take the step into the shoes of a different creditor?
Subrogation.
Yes, sir. Very good. It was subrogation. So he's claiming he is subrogated to these other debts as well. So he wants all the money. Okay.
I'm believing the defendant is arguing that the defendant argues that the plaintiff knows the purpose for the money.
The purpose for the loans.
For the loan, yeah. Basically he's arguing that it was a loan and maybe not something else. And so he says, since it was for an illegal purpose, the obligation is unenforceable.
Right. It's null. It's absolutely null.
Absolutely null because it's illegal.
Because it was for an unlawful purpose. And what does the court say?
The court says he was not an innocent bystander based on the fact that he had some sort of relationship with the plaza.
Right. So this ties into cause how?
Well, there was the cause is an illegal cause.
Right.
And
so, what is the illegal cause?
Gambling debt.
Right. And what is the object as opposed to the cause? Object of the contract was the loan of money, right?
Yeah.
Was money. Is there anything unlawful about loaning money?
No.
No. But the cause, the reason for the loan was unlawful, and that's why this is absolutely null. Does he get his money back?
No, he doesn't.
No. Essentially, this is back to where the law finds that the parties both have dirty hands, unclean hands. Leaves them where they found them. Okay. There was another case, Lammy versus Will. These guys are playing poker dice behind some business, and guy borrows money so he can bet, but the money he borrowed, the other guy knew that he was going to use it to gamble with, so cannot be enforced, right? And the judge says something like, it's worse than playing with a bad loser is playing with a bad winner. I mean, that's kind of the guy that actually won, and he still refuses to pay the loan back. So what has this got to do with today's gambling? Because we have gambling houses here, right? These articles don't look like this one and 2984 haven't been changed since what? 19th century? We're talking about chariot racing, right? Shooting. Those are okay. Well, if I go into Harrah's in New Orleans, am I doing any of those? What are those enforceable or not? If I were to borrow money to gamble there, I think that would be enforceable or unenforceable?
I think it would depend if they knew that you were going to gamble with the money that you borrowed, right?
There have been some anomalous decisions on this. There was one decision where called Lauer versus Catalanato, where two buddies go to gamble in Vegas. Okay, before they leave Louisiana, one says, well, I'll supply $10,000 for us to gamble with, and you can pay me back when we get back home. Is that going to be enforceable? No. When they get to Vegas, they lose that money, right? And as they're packing up to leave, the one who lost the money turns to his buddy and says, can you give me $1,000? And the guy says, sure. He takes the $1,000, he goes running down, gambles it away, comes back up. And so the one who didn't provide the $10,000 is now out his own $1,000. He can sue on that, and he gets his money back because the court said, well, he didn't know that you were borrowing that $1,000 to go gamble with. But you can't get the $10,000 back because you both knew you were going to gamble with it. Somewhat weird, right? Okay, yeah.
Is there any, when they're doing these cases, implied reasoning? Because to me, it's kind of like you're in a gambling house, or you may be in a hotel, and there's buses.
It gets weirder. It gets weirder. In Telerecovery of Louisiana versus Major, guy gambles in one of the Louisiana casinos, okay, run by Telerecovery, and the house loans him money, okay. He signs a check that he can't afford to pay back, gets his chips, and goes on. And the court says, well, there's no way that the gambling house knew that he was going to gamble with those chips. He could have done lots of things with the chips. What? Are you kidding me? This is one of the two major decisions. The other one says, oh, well, these articles were impliedly limited when Louisiana legalized gambling. If so, there's a law review article out that argues, well, they might have been impliedly limited, but if you look at 2983, the last sentence says that as to such games, they're referring to legal games, the judge may reject the demand when the sum appears to him to be excessive. So can courts limit gambling debts? Would that help if you have somebody who's addicted, whose family, it hasn't been used, but you're straddling the fence? But if you have a client, you might get a judge that's open to that, So it's an interesting side effect. Here's another illegal cause. This is at the time where husband was the head and master and he paid all debts. So when it came to divorce, he was paying the debts of both parties, to paying both lawyers. So wife goes to PI and she says, I want you to get the goods on my husband. Okay, I want you to catch him cheating. Get some good photos. And so he follows the husband around for a while, gets some photos, and eventually they get divorced. And she's not paying, so he sues husband, right? Because husband's responsible for these debts. And husband says, it's got an unlawful cause, I'm not paying it. Okay? And the court agrees. Why? Why? I want you to get the goods on my husband, get some pictures of him cheating. Yeah.
She would use the information in order to maybe obtain a divorce, and if that was part of the cause, maybe that would be unlawful.
Let's think back to public policy. What kinds of things are limited by public policy? Things that are in derogation of marriage, right? Unlawful, a wrongful life, restriction of trade. What's wrong with that contract? Private investigators are hired all the time to see if somebody's cheating, committing adultery. But I just said something different than was in the contract. The difference between hiring a PI to see if somebody's cheating and hiring one to catch the spouse in the act of cheating. Okay? When you won't pay them unless they get the goods. Okay? In the latter, what is the PI encouraged to do? It's like giving somebody interest in the succession. He now has motivation to set the guy up, right? To set up a situation where some woman comes onto him and then to take pictures of the resulting implications, right? Yeah.
What was the name of that case?
The name of that case is McMahon versus Hardin. McMahon versus Hardin. Hardin. I can give you the citation too. Okay. Let me see. Citation for McMahon versus Hardin is 121 Southern 678 Orleans Circuit 1929. Okay, now we're up to 255 Davis Del Cambre Motors versus Simon. Weird case. I think I read this one myself 3 or 4 times. Anybody got it? Anybody want to talk about it? I see a lot of head shaking.
In this particular case, you remember,
Car dealer.
in this case, Mr. Mitchell purchased a 52 Chevy from the plaintiff
Mm-hmm.
and gave him 2 separate checks, one for $200 and one for $400.
So it was a cheap car, but the checks were even cheaper because they were rubber.
Right, the checks were issued on a bank in which he didn't have an account.
Right.
So,
Apparently before the dealer finds out the checks are bad or makes a fuss about it, Mr. Mitchell goes to his boss, Mr. Simon.
correct. Mr. Mark Simon issued a promissory note for the checks. And it's kind of disputed, but
So Mr. Simon allegedly goes to the dealer and says, I'm good for it, he's my employee.
don't prosecute for
Well, he says, here's my ex.
Right.
We don't know about the no prosecution, because if it was an agreement to not prosecute, it was
An unlawful cause.
unlawful cause. But then on appeal, they look at the facts again, and what does the appellate court say?
On the appeal, the court held that, Simon's efforts to seize a lawful prosecution was not a valid cause, with promissory note given on Mitchell's behalf. As such, the suit to recover $300 from Simon was dismissed.
Yeah, but it gets harder than that, doesn't it? Let's see, 255.
They address the forbearance of prosecution.
In the, let's see, 250, 260. Yeah, and this one they say it was a failure of cause because it was unlawful cause. But this was in the first time in the Third Circuit, right? What does the dissent say?
The dissent says that there was no evidence Mitchell had committed a crime, so there was no evidence that he had written worthless checks, that proper notice was given to Mitchell for payment.
It also says that Simon, at the time he executed and delivered the note, he didn't know that Mitchell had signed any checks in favor of Davis, and he knew nothing about the possibility that Mitchell could go to jail. So he wasn't giving the checks to stop any prosecution, right?
Right, and that was the disputed part.
That's the disputed part, yeah.
And he said he did.
And then we get the Supreme Court decision. What does the Supreme Court say? Oh, the irony of this.
I don't have that part.
Okay, well that's given in the case book starting on page 259. Starting on page 259, the two witnesses to Simon's signature. Apparently Simon, the boss, was illiterate. And plaintiff never asked him to pay. He never promised to pay. Mitchell worked for him at the time. He knew Davis was familiar with the car Mitchell bought. He went to see Davis about taking the car back. Davis didn't tell him anything, though Mitchell had previously been in trouble. Mitchell previously helped by putting an X on the document. He didn't know who signed his name. Concerning the checks Mitchell gave, Simon's testimony was very confusing. He saw them in a lawyer's office. He didn't indicate there was any pressure on him. He testified he didn't know Mitchell was in trouble or anything about the checks. So the horrible irony here is that the Supreme Court reverses the lower court, I think, which was the Third Circuit, and they find on page 261 that the debt due by Mitchell to plaintiff was sufficient consideration to support Simon's promise to pay. Ouch. So now the poor boss, right? He was better off before, right? Now he has to pay. So the irony is because he didn't know at the time that his employee had used worthless checks, he's now obligated to actually pay the loan. Weird. And I'm still not convinced that he actually signed those checks, right? Right, because, you know, whose X was it? Did he actually sign them himself? If he's illiterate, then it doesn't mean that he can actually write his name. It's not clear that he even signed them himself. So it sounds to me it was not a good case. Now, have I outrun you guys? Nobody's going to get kicked out on a Saturday. Have I outrun where you read to? You guys have. How many of you have finished where you read to? Okay. How many of you have read a little bit farther? Okay, it's about 50-50. I will continue a little bit. 262. Aaron versus Parrott. And again, I don't really like this case because I don't think it really is telling you much about cause. What is the purpose of this case? This is the one about the lady who refied her house with the law office, and then years later the law office discovers that the bank never actually came through the money for her loan, and so they sue who? Do they sue the bank or do they sue her? They sue her, okay? Which sounds terribly unfair. And the court originally says, what? Pardon?
Originally found for the plaintiff, so the opposing company found for them and said she owed all the money.
Right. And then what happened on appeal? Yeah, it's reversed on appeal. The lower court examined the validity of the note in light of consideration. Okay? And that was a mistake. On page 264, the court says that cause and consideration are not the same thing. Louisiana does not require consideration for a promise to be binding. Consideration requires an exchange, a bargaining, but cause is more subjective. I think that's the only really useful part of this case, because it otherwise seemed like a rabbit hole that the trial court went down. Okay? The true part is that Mrs. Parrott, was under the impression that she had gotten approval from the bank, right? Who signed the bank approval? Well, that was the lawyer who's now suing her, right? It was the closing lawyer. It seems to me that that, on his part, was shady business. If I were a real estate lawyer, would I sign as proxy for a bank an approval for a loan? Yeah, no.
And how often do attorneys' firms front the money at closing?
Right. Yeah, that seemed very odd to me as well. You know, what in God's name are you doing? Okay. You're fronting the money and then you're turning around and suing her when she never actually got the loan. So there is, they're saying that there was no, cause on her part if she didn't get the loan. And actually, ABN, if ABN did not consent, I think the concurrence was right, then it's the only one that can bring a cause of action for relative nullity. Okay, let's stop there, okay? Let's stop there. There's the multi-purpose heater case. I think I'm going to skip because it's tied up too much in some convoluted sales doctrine that you guys really don't need to know at this point, okay? It's talking about inhibitory defects. The dissent on that case by Justice Tate is the only one who got it right. I will talk about First Louisiana Bank versus Morris and Dickerson, but I prefer to do that when we've got everybody because I think it's a useful case for review. It reviews what concepts? Well, it's going to review formality of the writing, right? It reviews stipulation pour trois, and it talks a little bit about detrimental reliance. Okay. But that's enough for today. Come on, stop. Stop, stop. Trolls. Are you actually going to stop? That's the last case. Right. Pardon?
Do the next section, what are you going to
Effective obligations, yeah.
Relative simulation. Do you guys know why I'm holding all these Saturday classes? I just want to refresh your memory. I have to make up classes that I missed. It's an obligation at Southern. And I'll be missing 3 of your classes. I'll be out of the country from March 6th. And I don't get back until the 14th. That's 3. And so you'll have made up 2 of the 3. Actually, because I was sick once, I make up 1 more, but I'm not planning on meeting next Saturday. Because I think you guys will take a break. Yeah? Yes?
Yes.
I think we do.
Pardon?
And we can do like a webinar, like you did the last time, how we did.
Yeah, make a video from wherever you're at.
Or make a video and send it to you.
Because we've also got torts
Okay.
review sessions on some Saturdays, which we still have to make up
Okay.
classes that we missed from others.
She's a Monday
I think
class,
we've
and every
had-
time we have a holiday,
Yeah.
we don't have class.
We've only had class probably the last 3 weeks. We might have had class 2 weeks ago.
What, for torts?
Yeah. We've only had maybe 3 or 4 classes.
We've covered maybe 17 cases since the beginning of January. That's a lot.
So
Maybe
Is your torts professor an adjunct or full-time?
And it's her first year teaching.
Please let Chancellor Pierre know about this.
We kind of do torts by committee, we're good.
Yeah. I mean, if you have to have a weaker teacher, torts is an easier course, but you're gonna have to teach more of it to yourselves. And the chancellor should be made aware of that so that you're not disadvantaged when you get to the final exam.
More so than that, you're gonna make it to the bar,
Yeah.
and we never talk about strict liability.
Strict liability is actually pretty easy.
we did talk about strict liability.
No, she wrote it on the portal.
Strict products, are you talking about strict liability or strict product liability?
The product liability.
Product liability is about 4 statutes, it's really not hard to figure out.
I'm trying to read off myself. Go on.
Do I have somebody who wants half of that king cake? Do you have my Do I have anyone who wants to take some king cake to go? Love some help.
Yes.